This brief, as your honors are aware, focused on two issues primarily.
Rebuttal time?
Rebuttal time of 3 minutes, please. Thank you. I think the heart of this case and the most significant factor on this case is the issue regarding self-defense. Self-defense is the entire case here, because without self-defense, essentially what you have is someone saying that the defendant committed a crime, and that this crime involved the killing of someone or the attempting to kill someone. Whether that conduct is legal or illegal would determine is whether or not self-defense is there. So without self-defense, all you have is that a killing and an attempted killing happened. And so that was the heart of the case. I think trial counsel acknowledged self-defense was the heart of the case. The defendant / appellant during the post-conviction hearing acknowledged that that was the heart of the case.
That's your first issue, right?
Yes.
Okay. Well, I think there might be another issue. I'm going to ask the state to comment too, but the written order in this case, the post-conviction's written order, do you have a copy of it? I've got a copy here.
Not in front of me, no.
In my review, the statute 40-30-111B, I believe, requires there to be the written order to have findings of facts and conclusions of law, okay? Let's say, and the Supreme Court 2 years ago in Tate v. State, and the citation is 679 Southwest 3rd, 631, required that the written order contain such things under the statute. All right. So what is your position if we determine the written order is insufficient as far as remanding it for the court, the post-conviction court, to comply, and having that done before we reach the merits, including reaching the merits today as far as arguing the merits?
I would agree. I think that's fair. I would have no issues with that.
And just to be clear, Mr. Student, and for the state as to why, if you look at the trial court's order, she basically, the trial judge post-conviction judge just basically recites Mr. Ganguly's testimony and then dismisses the petition.
Correct.
Which would not be compliant with, you could argue those are findings of facts, but there doesn't seem to be truly conclusions of law with the order. The question I would have, to piggyback what Judge Wilson just asked, what about, and I have not looked at it, so either party can answer this or both. What does her oral ruling at the end of the hearing say? Can we, if we wanted to, can we get enough from an oral ruling to say that, yeah, the order doesn't comply, but she made those findings? Do you recall what's all in the oral ruling?
I don't recall what's in the oral ruling. I do believe that she made comments during the hearing. Typically, that's what she does. I don't recall. I'm not going to pretend like I do. I don't recall what the oral ruling was.
And the only thing that I'll say, just in the future, Mr. Tootin, with some of your briefs, you might want to incorporate, how you're challenging the order, so we can see what your position is fully on these issues, so you're not caught off guard.
Yes. And on that issue, I had to be honest, I did not address that because I've seen, quite frankly, lesson orders that seem to slip through the cracks and go by, so I let that one go. So,
You
but I
unfortunately
appreciate
pulled a
it.
panel with someone who may have been, who may have had the case that the Supreme Court took that says you have to do this. I'm not gonna point any fingers.
So,
but
I mean, I agree, though. I appreciate it, but, so if that's, I don't know if that ends the conversation or,
No, you can make your
Okay.
arguments, please.
and so as it relates to the issue of self-defense, with that being such an imperative issue, and again, with post-conviction, the question is whether or not the trial counsel's was deficient and whether it prejudiced the defense. My client or the defendant made clear testimony that he believed that self-defense was going to be the basis, so there's no dispute between him and trial counsel, but he believed it was going to be basis significantly supported through the statement of the co-defendant. That is represented in, I believe on volume 2, starting on page 34, is when the defendant starts testifying. And he talks about the strategy being self-defense on page 35, and that he would be relying on the co-defendant's statement, and that he was not aware that the co-defendant's statement would not be used. Now, trial counsel, interestingly enough, explained that he was using a joint defense with the co-defendant. And I understood him to be saying that they were going to be hammering a lot of the same points so that they basically kept the case together, and that he did not, as in trial counsel introduce the statement because he didn't believe he could because they were being tried together.
All right, so you've got the statement. You're saying he's ineffective because he failed to introduce the statement. And to do that, perhaps sever the case.
Correct.
Do I have it correct?
That's
All right.
a big part of it.
So tell me how the statement, under the evidentiary rules, and maybe Bruton, but how would the statement, I believe in your brief you said it's a statement against interest potentially, and it would be an admission of the party opponent. All right. How is it a statement against interest if it exculpates, if it potentially clears the defendant?
Because it's a statement against the co-defendant's interest. It happens to be in the interest of my client, but it did not benefit the co-defendant to make that statement, is what we're saying. But in addition to that, with that concern where we're talking about the statement, because these arguments it's all stemming from that issue. But if the alternative is, because trial counsel seemed to say that the reason he didn't introduce it is because they were being tried together. But he said they were being tried together because they had a joint defense. But he doesn't dispute that the statement may have been helpful and that the only way he saw he could get it in is if they were severed. So that doesn't make much sense then to not rely on the statement, especially when the defendant believes that that is the heart of your self-defense argument. And there's nothing in the record to contradict that this is what the defendant was led to believe, which leads me to my next point, is if that is something that is not going to be explained in a way to the defendant clearly to say, let me make it clear to you, this statement cannot come in, this statement is not being used. He needs to know that because part of the decision he's making is whether or not he wants to go to trial or take an offer. He's going to trial under the belief that my defense will be this individual's statement, or in the alternative, this individual is going to testify. Because it also came out during the hearing that they were doing these sessions together, and that it was made clear to the trial counsel, the defendant testifies, that
Well, let me ask you
the
this.
co-defendant would have testified.
On that point, Mr. Tootin, let me ask you this. The way I read it is, yes, as you said, that came out, but the only person that testified at the PC hearing that came out
Yeah.
prior to trial is your client. You didn't bring
Yeah.
the co-defendant or co-defendant's counsel to say, yes, we had agreed that, I can't think of the co-defendant's
I
name right now.
understand. Mr. Quentin Brown, I believe it was.
We agreed that he was going to testify. So the only proof that's offered that the co-defendant was going to testify is your client.
So I would add a little to that. That is part of the proof. So this is why I say it's additional that. You have the client saying that. You have the trial counsel saying that the defendant he found him to be credible and that he did not have any specific recollection, meaning trial counsel didn't get up and say that never happened. He knew that there were sessions. And then you have the state not challenging that in any capacity. So I think when you take all of that together, then I think that's enough to get us clear and convincing. You have someone who unequivocally remembers it, trial counsel saying, well, I don't necessarily remember it one way or the other, but I find him to be credible, and then
But
no
Mr.
one
Tootin-
saying otherwise.
Mr. Tootin, the burden of proving a factual allegation by clear and convincing evidence is
It's
on
us.
you.
Correct.
The state doesn't have to prove
Correct.
anything.
Correct.
So, again, clear and convincing evidence of the defendant testimony, I don't know, I think you're going to be hard pressed
See-
to find a lot of case law that says the petitioner testifying to something that's not corroborated at all at a post-conviction hearing meets the threshold of clear and convincing evidence.
And what I'm asking is when we're using the phrase not corroborated at all, what I'm saying is when you have someone testifying under oath under penalty of perjury and then trial counsel not refuting it and then no evidence ever being entered to the contrary, I think that is pretty clear and convincing. But even if it were not, essentially that issue goes towards whether or not the co-defendant wanted to testify. That still would not change the fact that the defendant was believing that the statement would come in.
Let me just make sure I'm clear on something. Your issue, you have two issues, correct?
Correct.
The first issue is that the counsel was deficient in failing to admit the co-defendant's statement.
Correct.
And the second is counsel was deficient in failing to file a motion to sever.
So the second issue deals with a lesser included offense, which I'll get to. But the issue about the severance relates back to the issue about the co-defendant, in that if trial counsel was saying, which he said at the hearing, that he doesn't understand how he could have got the statement in if they're not severed, then our concern is, then why did you then tell us prior to that statement that you were proceeding under a joint defense? What was your benefit of intentionally going under a joint defense if you're telling us under oath that while going under this joint defense, you now do not know how to get this statement introduced into evidence, and that you believe the statement may have been helpful? So our concern is, one, if you're not going to be able to get it in, it's one thing if you can't get it in because you've done everything that you knew to do. It's another thing not to be able to get it in because you put yourself in a position which makes it impossible. Doing a joint defense because your argument, I believe, was he wanted to hammer a lot of the same issues that was going to be argued with the other attorney, that is not a sufficient basis to lose this opportunity to get this information in. But in addition to that, my second point that branches off of that is, if you are in fact not going to go forward with that statement or not going to attempt to get it in, then you have an obligation then to sit the client down and explain, this statement is not coming in. I don't see how it can come in. How, do you still want to proceed to trial? Do you want to try to resolve this some other way? Because the defendant testified, this is what our strategy was, and this is what I was basing going to trial on, this belief that it's self-defense based on this statement. Because outside of that, you just have the state's case. You just have the state's version of events, you have the state's facts. And so that's where the concern is, because self-defense has to come in from somebody saying something about self-defense to defend it, is our position. And when you undercut the strongest information that supports that, that's where he's unfairly prejudiced, and it prejudices the defense because it impacts his decision-making of whether he would have went to trial versus an offer versus something else. So that's the concern for that issue. The other issue is dealing with the lesser included offense. I believe I called it count 3. I need to correct this. It's count 4 of the indictment. The count 4, volume 2, I believe it's volume 1, I'm sorry, deals with the lesser included. There's an attachment. The fourth count is employment of a firearm during the commission of a dangerous felony. I believe I called it count 3. Count 3 was a convicted felon in possession of a firearm, I believe. So it's volume 1, pages 9 through 16 that have the different charging documents. The argument I'm making on that one is I would ask this court to consider and issue a ruling that allows what we believe a true and pure protection of a defendant's constitutional rights in this instance. If a defendant asks for a lesser included offense and the law supports it, it's given. We've seen case law that talks about how jury instructions and complete jury instructions are appropriate. However, if a defendant fails to ask for a lesser included offense and the judge doesn't give one, it can be considered waived. The court, I'd be standing before your honors asking for, hey, is there something we can do here? And you would politely tell me the law doesn't allow any relief. It was waived. It should have been raised. So what we're asking for is a clarification on this other category. Here, as it relates to count 4, employment of a firearm during the commission of a dangerous felony, which was a criminal attempt second-degree murder. Trial counsel and defendant were adamant. They did not see a scenario where he would get convicted of second-degree or criminal attempt second-degree. They just did not see it possible. And so as it related to count 4, the same way it can be waived, your lesser included, if you forget to ask for it, a defendant should be able to waive a request for lesser included and say, on this count, I want it as is, all or nothing. The state did not file a request for lesser included. The defense, under his constitutional rights, to his right to liberty, under these same rights, should be able to say, on this count, you charge me with employment of a firearm during the commission of criminal attempt, second-degree murder. I don't believe you got the goods. I want to be charged as that. I do not want a lesser included. I do not.
An all or nothing defense.
Correct.
Okay, so the state cited TCA, perhaps you did too, TCA 40-18-110B. But are you familiar with subsection D?
Yes.
Okay, so what do you believe this language means? I assume through your scenario, the defendant would have lodged an objection to the proposed lesser. Is that fair?
Correct.
Okay. Here's the last sentence of subsection D. The defendant's objection shall not prevent the district attorney general from requesting lesser included offense instructions or prevent the judge from instructing on lesser included offenses. That's from the statute passed by our assembly.
I agree.
So how do we deal with that?
And what I'm asking is that this panel make an interpretation that under the United States Constitution, as it relates to your rights and your liberty and your freedom, that is not consistent with giving a defendant his full opportunity to make a decision about his life, because when you forget to ask for it as a defense, it's waived if it's not given, and they're stuck and they have to live with that. Well, if this is his life and it's his liberty and it's his choice, he should be able to make his choice fully, and it shouldn't be stacked one way or another if we're talking about fairness, due process, and equal protection. I am conceding that that language is clear, unambiguous, and it means what it says. I'm not arguing that that language is unclear. I'm arguing that it's unfair, and I'd ask the panel to find it unconstitutional. That's what I'm arguing. But I understand it, and it's there, and it's very plain.
Thank you, Mr. Tootin.
Thank you.
And you still have your, I think, 3 minutes if you want to use it. Mr. Barton?
Did you pull up the Tate case?
Barker.
I don't have, I did pull up the Tate case earlier, Your Honor, but before that, I pulled up the transcript.
All right. What's your position, because on what I brought up first with Mr. Tootin?
The written order is problematic.
Okay. So what
maybe
we've
to
done,
take a favor.
what we've done in at least one past case is hear the argument today, remand it 30 days later. The court, post-conviction court will comply and will allow for briefing, and normally the parties don't because they've argued the merits today. So any objection to that procedure?
If this court sees fit to do that, I don't believe I can stand in the way.
All right.
Fortunately, perhaps, the post-conviction court discussed its findings and made a ruling from the bench.
Well, that's
at
what,
the end
I
of the
mean,
hearing.
you pulled up the transcript. I don't have
did.
the transcript in front of me. Everybody on this panel is familiar with the post-conviction court, and what I didn't know is whether there were certain findings within the oral, I guess, communication of her ruling at the end that may save the order or may be incorporated into the order.
The post-conviction court discussed the evidence that had been presented and made definitive rulings on the severance issue and this all-or-nothing strategy issue as to the lesser-included offenses.
Okay.
I wish that, I certainly wish that the post-conviction court had incorporated all of that into its written order.
Okay.
Certainly makes my job a little harder today, but it's in the transcript.
Gotcha. So just to follow up on Judge Wilson, you're not going to take a position on us remanding it back such that the court can comply, so we don't have this issue repeatedly.
I'll take no position on that, Your Honor. If I might turn to the merits now. First, trial counsel just was not ineffective for failing to seek severance. Trial counsel explained that he and Mr. Brown, the co-defendant's counsel, pursued a joint self-defense theory. So they had the same theory of the case, right? And that the attorneys could clean up anything that the other might have missed. So he didn't ask for severance. That was reasonable. Respectfully, I think that the arguments that are made here about severance are really just Monday morning quarterbacking again. It's the wrong inquiry. It's not whether there may have been something better out there. It's whether what trial counsel did was objectively reasonable or unreasonable. And here, it was just objectively reasonable for him to take this approach. And there's just no prejudice here either, because petitioner has not demonstrated that a severance motion would have been successful, that Mr. Brown would have testified in his defense, or that his trial's outcome would have been different if the cases had been severed.
Is it reasonable, though, if trial counsel is telling his client, hey, we're going to try you two together because you have similar defenses, and that is it's self-defense. And hey, the best part is he's given this statement, which is good for you. It's bad for him, but it's good for you. And that's going to be good when we go to trial, knowing there's no way that statement's coming in. I mean, how can you be effective if one of two things there? Either, well, I guess one of three. One, he never told him that. But two, he told him it was coming in, and he doesn't understand the rules, which would be ineffective. Or he told him coming in knowing it was never coming in, but that was the best way to get his client to go to trial.
I don't recall specifically what trial counsel's testimony was at the post-conviction hearing as to what he told petitioner about Mr. Brown's statement, or whether it was just petitioner who had this idea that the statement was going to come in at trial. Either way, whether it's severed or not, the statement still doesn't come in. Yes, if it's severed, you've cured the Bruton problem, but to cure any hearsay problem, Mr. Brown has to testify, and Mr. Brown did not testify at the post-conviction hearing, which is fatal to this claim. So ultimately, the state's position is that there was neither deficiency nor prejudice established here. Next, trial counsel was not ineffective for not pursuing this all-or-nothing strategy as to count 4. Petitioner claims that trial counsel should have requested that the trial court only instruct the jury as to attempted second-degree murder as a predicate offense for employing a firearm during the commission of a dangerous felony, and not instruct on any lesser-included offenses. This was a really risky trial strategy to start, so it was not deficient, certainly no deficiency that petitioner has established outside of hindsight. But as the panel picked up on, there's just no prejudice here because the trial court could have instructed on the lesser-included offense of its own accord. Petitioner's objection at the trial, it could have preserved the issue for appeal, but that doesn't change that the trial court still could have instructed on the lesser-included offenses. I find this kind of constitutional claim about these lesser-included offenses a little odd. I don't recall seeing that in the briefing or reading about it in the transcript. If it's raised for the first time on appeal, it's waived. Similar to
Can this court even find a statute unconstitutional?
Under these circumstances?
I don't think so. There's just been no straightforward constitutional challenge here, and even if it's waived,
Especially when he says it's plain and unambiguous. I mean, there's no
the
question what
statute
it
is what the
says.
statute is.
And all our statutes are presumed constitutional.
And turning now, the petitioner seems to raise a standalone due process claim in his brief. It seems that he alleges that his due process rights were violated because he received the ineffective assistance of counsel. Those seem like distinct concepts to me, but either way, there was no standalone due process claim raised below, so any such claim is waived at this point. So I understand the panel's problems with the order, But the state nonetheless respectfully asks that this court affirm the denial of relief on the merits. Thank you, Your Honors.
Thank you, Mr. Barker. Mr. Tootin? You have your 3 minutes, sir. If you want to use it, you don't have to.
Mr. Chief, let me ask you this.
Yes.
Since your claim is a claim on the lesser included issue, is a claim of
Yes.
ineffective assistance of counsel for not asking
Yes.
for an all or nothing. How can we, I get you think the statute should be unconstitutional, but that's really a separate issue. How can we find an attorney deficient or find that he was prejudiced if all he did was follow the law?
Quite honestly, what I would hope to happen if Your Honors chose not to find him deficient would at least be some strong language in the opinion,
So you
whether dicta or otherwise.
You recognize we can't
explaining.
actually find ineffective assistance because counsel followed the law. You may disagree with the law, but he followed it. Now,
He
you may
followed-
want
he followed
us to
the
give us
law as
an
written.
advisory opinion, so to speak. Okay.
I don't want to concede much other than I do agree that he followed the law, but whether or not that's fair to the United States Constitution, or if Your Honors feel otherwise, to include some language in there that at least addresses it, whether binding or otherwise, I think that would be a helpful starting point for this. But I will say, as it relates to the judge's statement that we were talking about in her ruling or oral statements, one of the things she said that's very important, and I believe this is in volume 2, that's the hearing, starting on page 74, there's a quote from lines 24 to 25. I believe everything that Mr. Howard said he believes. That's the end of that one, and then it goes to page 75. He believes that Mr. Brown, Quentin Brown, was going to help him. He believed Mr. Brown's statement before, after, during, at the meeting would assist him during these proceedings. I don't doubt for a second that he hung his hat on that. And she goes on to say more. She's commenting out loud prior to making her ruling. She's making some of those comments. But that again goes to a point I believe, Judge Dyer, you mentioned a little bit about it. The mere fact, if you don't believe anything else, if we know that that's unequivocal, the court seems to also have found that believable or credible, that if this defendant is basing his entire defense on a statement he 100% believes is coming in, that trial counsel did not clarify, is not coming in, doesn't understand how it would come in, we cannot say that that doesn't prejudice the defense or that that doesn't prejudice the defendant's decision-making at that point. He doesn't know the law. He's relying on trial counsel, and he's relying on the belief that this statement is coming in. In the previous case I argued, we talked about credibility findings. It looks like from a credibility standpoint, Mr. Howard was found very credible. And if he's very credible, that goes back to the other issue that was raised earlier. Is his statement alone enough to be sufficient? With this trial court, it appears like, yes, his statement carries a lot of weight. And so for those reasons, I'd ask that you reverse and remand. It sounds like it may go back on other reasons, but we'd ask for one of them be that and some type of opinion on the lesser included issue. Thank you.
Thank you, Mr. Tootin. The case will be taken under advisement. We appreciate both of your arguments today and the briefs. Oh, yes. This court is going to stand in recess for about 5 minutes.
All right.